It's great to be back with all of you. The last time I was speaking with you, as memory serves, I was in Washington, D.C., walking past cherry blossoms. We still have a few of those left in New York City, but I observed in my neighborhood in Brooklyn that they're turning into actual leaves now. So we're getting closer to summer. It's beautiful here in New York City today. We have a lot to cover in the webinar, including, as of late last evening, a agreement in principle on the budget in New York State. So I'm here to wear that hat as well, and along with Roger Bearden, as far as telling you what it is that we know and what we don't know. So in a moment, Roger and I will get started in covering that material, but let me first walk you through the agenda. So as I mentioned, we'll be addressing the budget details, which will be filtering out over the course of the balance of this week, to be clear. But we've been waiting and waiting, and now finally we have something. And then after that, we will shift to Krista Cook, who's with us from our Syracuse office and has been on the webinar many times over, familiar to many of you, I'm sure, who's here to discuss a new federal executive order that aims at eliminating disparate impact liability. Then we'll be hearing from Barbara Lee and Kim Wolcott-Eggery, who are both as well members of our team that you've heard from before here on the webinar. And they'll be talking about a distinct federal executive order, and that one concerns higher education accreditation. We'll try to wrap everything up in about 30 minutes from now. And so with that, Kathy, why don't we move then to the next slide? And the one after that, please, would be great. So as I mentioned, there was a handshake last evening, at least a virtual one. None of us was, per se, there to witness it, but the governor came out with a press release and other information suggesting that there's an agreement in principle as among the houses and the executive on a $254 billion general agreement. There's a short extender to keep the government funded through May 1st that is being taken care of. And so we expect this budget ultimately to get done, as it were, by May 1st, which means that all of the nitty-gritty will be getting released over these next hours. We will be pouring through all of it to figure out what it is that wasn't among the top line announcements, but that matters to all of you. And certainly in our coming programs, as well as through informational memoranda, you can expect to hear from Roger, me, and the government affairs, or rather the Government and Regulatory Affairs Group. And so there'll be more to come. But let me just quickly tell you what we know. The governor had been pushing for many weeks now for a ban on cell phones in schools used by students during school hours. That seems to have made it. There was a vigorous debate about masking, and that came in the context of some of the protests, whether institutions of higher education or otherwise, where masking became part of what was the subject of discussion, and whether it was or was not something that should attach to rather specific criminal sanction. It sounds as if, based on the reporting, that there will be some enhancement for committing a crime with a mask, but it'll be very modest, which seems to be a middle ground of sorts. There's discovery law change, which we're getting the details on, but the governor had been pushing for that as well. You may remember in the governor's State of the State, she called for a wide array of rebates to New Yorkers. Those rebates are being issued to those with the least incomes, both individuals and families, at fairly modest amounts, per year. I think under $500 for each of these payments. And also a late-breaking addition into the budget that I had mentioned in an earlier broadcast. Of course, Lieutenant Governor Delgado and Governor Hochul are not running together, for Governor Hochul's efforts at re-election. And now in the budget, there's language that specifically aligns the lieutenant governor and gubernatorial tickets into a fused ticket, which is a change for New York. Left out is a bunch of things, at least based on what we know, and more to come. But Roger, why don't you walk us through what we have heard and what we're seeking to learn? Roger, you're muted. If you don't mind coming off mute, please.
Thank you so much, Gabe. I was adhering to your admonition to stay unmuted when I wasn't speaking. So there you go. So one of the things that frequent listeners would know that has been a topic of controversy has been the changes to the consumer-directed personal assistance program. To the best of our information, there is nothing in the budget that will address that. We also don't have a lot of information about what has made it to the end of the budget on Medicaid and human services funding. That is one of those items that is very often closed at the last moment. So there may still be some open items there, since nothing in the announcements that we've seen so far have given an indication on that front. Let me throw it over to you for the MTA financing point, Gabe.
Sure. And so, as far as the MTA is concerned, there was a bit of compromise here. There have been proposals to essentially tax individuals. The ultimate outcome, as we understand it, again, based on what's been reported, will be no, that won't happen for the purposes of generating MTA revenue, but there will be an increased payroll levy on certain companies, those with 10 million or more in revenue. And so exactly how all that shakes out, we will see and report on once again we have those details. But as we've shared in repeated webinar broadcasts before this one, the MTA's finances are intrinsically connected to the stability of the state's fiscal health. The costs of maintaining the MTA have been part of, and they are part of ongoing litigation, including with congestion pricing. I will tell you, as I peek out in Midtown in New York City, the streets are still looking a lot lighter in traffic than they did just 6 months ago. So congestion pricing, anecdotally, is working in terms of that goal of bringing down the packed nature of the streets in the city, but it remains a very much open question whether that funding and the revenue that derives from that policy decision will remain in place or not. So more to come on that. And speaking of more to come in general, Roger, what do we know on the federal side? There is, of course, a lot that's been rumored. We don't know exactly when whatever it is, will affect New York State. What are you hearing?
So from the Medicaid and health side, there is a very large target of a little under $1 trillion. I think it was about 880 billion. The last we heard that the needs to be saved nationally, and still rumors of changes in the Medicaid program as a primary source of funding. Lots of other things in New York State that, if you read the proposals, will be impacted. All sorts of federal programs that primarily support people who are poor, the unhoused, people who are dependent on public insurance of a variety of stripes. So this budget that has been passed or has a handshake deal is likely not to be the last word in New York State, as the full impact of those things are understood. There's highly likely to be more legislative activity later in the year as the state adjusts to whatever comes down the pike from the federal government.
Thanks, Roger. Yes, it is uncertain, certainly, in terms of what the import and finality, as it were, of this budget means for the state. And we'll, of course, keep all of you updated here in the webinar forum. So, Roger, thank you very much. And in order to keep things moving crisply, let me turn to our next speaker, who is Krista, as I mentioned, back on the webinar. She is here shifting gears to a degree anyway. We're talking about federal activity, as we exit the budget discussion and now move here to this next topic. But in specific, Krista is going to address a new executive order that aims at eliminating disparate impact liability. Krista, what does that really mean? I know listeners will be really interested in learning more.
Great. Gabe, thank you so much. And thank you all for tuning in again and joining us today. As you all know, there have been a lot of developments under the Trump administration since January, and we appreciate the opportunity to review them with you, at least briefly. Today, I want to spend just a few minutes discussing a new executive order that was signed by President Trump that impacts a wide array of us, certainly from the employment context, but in other contexts as well. If you could turn to the next slide. So on April 23rd, President Trump signed multiple executive orders, one of which was titled the Restoring Equality of Opportunity and Meritocracy. Through this executive order, and there was also a fact sheet that summarizes the executive order, so you can obtain both from the website. This executive order and the fact sheet, the Trump administration characterizes disparate impact liability as unlawful and states in the executive order that it not only undermines our national values, but also runs contrary to equal protection under law and therefore violates our Constitution. The premise and goal of the executive order is to eliminate the use of disparate impact legal theory in quote unquote all contexts to the maximum degree possible. Generally, the executive order is geared towards restricting the federal government, the federal agencies' use of this legal theory of disparate impact. But the Trump administration clearly seeks to eliminate the use of this, the disparate impact liability on a much more broader perspective. And again, the order goes so far as to characterize disparate impact as unlawful. The order states that disparate impact liability has hindered businesses from making hiring and other employment decisions based on merit and skill, and imperils the effectiveness of civil rights by mandating rather than prescribing discrimination. So for those of you who don't know or recall, what is disparate impact? What's the disparate impact theory that the government is seeking to do away with? Under Title VII and certain other civil rights laws, discrimination claims generally can be made under two main theories: the disparate treatment theory or the disparate impact theory. Under the disparate treatment, that generally involves allegations, let's say, for example, that an employer has refused to hire someone or has terminated an individual based on their race or their gender or national origin or some other protected status. It's generally viewed as intentional discrimination. The second theory that we're talking about here is the disparate impact, which generally addresses unintentional discrimination. And under the disparate impact theory, policies or practices that might appear facially neutral can still be found to be discriminatory if they disproportionately affect members of a protected class. This is not, the disparate impact theory has been around for a long time. The theory was first articulated by the United States Supreme Court in a case called Griggs versus Duke Power. And if in the employment context, when faced with a disparate impact claim, employers must show that the challenged policy or practice is job-related and consistent with business necessity. So where does this show up? Where do we see this disparate impact theory? The disparate impact theory has been codified into the statutory provisions of Title VII, and that was done in 1991 as part of the Civil Rights Act amendments to Title VII in 1991. So the disparate impact concept is part of the Title VII statute when it comes to the prescription of workplace discrimination under Title VII. The disparate impact theory is not explicitly addressed in Title VI, which covers discrimination in the education context. It more broadly prohibits race or national origin discrimination in programs or activities receiving federal financial assistance. But disparate impact is part of the Title VI regulations. So both Title VII and Title VI, these two laws, have ingrained in them the disparate impact liability. And over the past several decades, the disparate impact liability concept has become pretty commonplace in other laws, other civil rights laws, in a wide array of fields, including employment, access to credit, housing, and education. So since the quote unquote smoking gun, is not easy to produce for plaintiffs and is rare, intentional discrimination is, less frequently seen. The disparate impact theory has provided an alternative to plaintiffs and to the government as an alternative mechanism to enforce the anti-discrimination laws. This executive order seeks to limit the enforcement of civil rights laws to intentional discrimination by doing away with disparate impact theory. The executive order directs federal agencies to deprioritize the enforcement of all statutes and regulations to the extent that they include the disparate impact liability concept. If you could go to the next slide. The executive order also directs that federal agencies are to identify and repeal any regulations or guidance documents that have been issued by the government that utilize the disparate impact framework. It rolls back the implementation of Title VI for all agencies with respect to disparate impact liability, and also includes for the revocation of prior presidential approval of Department of Justice Title VI regulations to the extent that governed address disparate impact liability. In the executive order, there's also a direction for the government to review pending investigations and civil suits, as well as injunctions and consent decrees in which the government has relied upon disparate impact theory, and to quote unquote take appropriate action with respect to such matters such that it's consistent with the policy of the order. Generally, we assume that means that we will see the government sort of folding back and ceasing those investigations that are based on disparate impact claims, or at least changing their theory of moving forward. Interestingly, the executive order also directs the Attorney General to examine whether any state laws using the disparate impact theory may be preempted by federal authority, or whether such laws, regulations, policies, or practices have constitutional infirmities that warrant federal action. In other words, we may see the government trying to preempt and repeal certain state laws. I would also note that the executive order directs the Attorney General and the EEOC to issue a guidance to employers regarding appropriate methods to promote equal access to employment, regardless of whether an applicant has a college education. So we will see that forthcoming. So it's important to remember that the executive order does not change existing statutory law. The executive order does not and could not change the fact that Title VII codifies the disparate impact theory, nor does it alter the U.S. Supreme Court or other court precedent regarding disparate impact theories or liability. However, the order may provide additional arguments for employers in pending cases and in future cases in which any of these types of disparate impact claims might be made. Due to the statutory law, for example, in Title VII, and case law precedent that has been established under this disparate impact theory, private individuals will most likely continue to be allowed to pursue disparate impact claims in court, provided the courts continue to find and recognize these as cognizable claims. The executive order is really a broader part of a broader philosophy that aligns with Trump's other recent executive orders aimed at limiting diversity, equity, and inclusion. And many of those earlier DEI executive orders have faced legal challenges. In some cases have even been enjoined, including a Dear Colleague letter that was issued by the U.S. Department of Education's Office of Civil Rights related to Title VI and the DEI concept. So it's possible that this order may face similar legal challenges. We will have to wait and see if legal challenges are faced. This is certainly another area in which we may see a battle over state law versus federal law. But I think that's all we have on that. And I will turn it back to you, Gabe.
Thank you so much, Krista. Obviously, developing issues and the exact reach is something that we'll be tracking as attorneys. And if there's colorful information to put back out there in front of all of you, you'll have it. Krista's also written on this topic, and so you can find more information coming through our email channels. Let's turn to our last speaker for the program today, or speakers, I should say. Together, Barbara Lee and Kim Walcott-Agree will be talking about a distinct EO, this one concerning higher education accreditation. As we've been noting, these EOs are coming quickly. We are very much interested in knowing what it is we think this one is about and how it affects our higher education clients and others who may be interested in these details. So let me turn it to Barbara and Kim, who will be presenting together.
Okay, thank you, Gabe. We will be talking about this executive order. I do want to say from the beginning that its language is quite unclear, and we are describing what it says. It's going to take some time for all of us to figure out exactly what it means. So last week, President Trump issued this executive order. Next slide, please, Kathy. And it's directed at accrediting agencies. It's not directed specifically at institutions of higher education, but clearly it is going to have a very strong impact on colleges and universities if it's not challenged and if it sticks. So basically, it's requiring accrediting agencies, and I'll explain what they are in a minute for those of you who don't have close familiarity with them, to modify their missions, to remove DEI requirements, which most of them have, to focus primarily on student outcomes, and to compete with new accrediting bodies for placement on a list that I will be speaking about as soon as we see the next slide. So next slide, please. Thank you. So the Higher Education Act requires the Secretary of Education to issue a list of agencies that are approved to certify the quality of the education that a college or university provides before it can participate in the federal student financial aid program. And so this is where it's going to have a clear impact on colleges and universities. Most accrediting agencies have had clear DEI requirements for both curriculum and policies in their standards, and colleges were required to meet those in order to be approved to be participating in the federal student aid program. This executive order requires agencies that want to stay on this list that the Secretary of Education issues periodically to get rid of all of their DEI requirements. And so now Kim is going to walk us through what the executive order requires.
Thank you, Barbara. Good afternoon, everyone. So the executive order accuses many accreditors of abusing their authority and violating anti-discrimination laws by conditioning higher education institutions' access to federal funds on their adoption of DEI standards. Next slide, please, Kathy. So the order specifically singles out the American Bar Association's Council of the Section of Legal Education and Admissions to the Bar, as well as the Liaison Committee on Medical Education, which are both federally recognized accreditors for advancing discrimination in law school and medical schools by requiring such DEI standards. The order goes on to direct the Secretary of Education and the Attorney General to investigate these accreditors and determine whether to suspend or terminate their accreditation status. Next slide, please. As you can see, the executive order sets forth several principles that the Secretary of Education must assess in evaluating accreditors. You will see on the slide that there are a lot of directives and some of the language remains to be defined, and it will take some time for us to fully understand the full intent behind them. But just to summarize a few of them, it essentially states that accreditors must be more flexible and less prescriptive in the way that they allow institutions to operate. It also states that accreditors must ensure institutions hire faculty with a wide array of viewpoints to advance academic freedom, intellectual inquiry, as well as student learning. And it also states that accreditors cannot place institutions in violation of state legislatures, laws that state legislatures have passed regarding curriculum and the rights of students, which may include laws or references to DEI standards. Next slide, please. The order also sets forth additional requirements for the Secretary of Education. These requirements include recognizing new accreditors, which is aimed at increasing competition and streamlining the process for institutions to change accreditors. It also mandates institutions' use of program-level student outcome data, which is essentially student performance data, without referencing demographic factors such as race, ethnicity, or sex. It also requires that institutions are notified of non-compliance findings by the Office of Civil Rights under Title VI and Title IX investigations, and the launching of experimental sites to accelerate innovation and improve accountability. As it relates to the experimental site, there's already an existing federal law that requires this particular mandate, but it remains to be seen what the requirement in this context entails. I think that is all for my section. So thank you so much, Barbara. You may continue.
Okay, thank you. Next slide, please. So what does all of this mean for colleges and universities? Well, we are making guesses right now. It remains to be seen how much of this actually continues, but if the Secretary of Education enacts all of the requirements of this executive order, and I have no reason to believe she will not, then institutions will have to change. It's pretty clear from the executive order that the graduation rate is felt to be too low, and I think many of us would agree with that, and that the burdens of students of student loan debt is too high. So one of the things that I think we will see is colleges and universities focusing more on career preparation. That will probably mean that there will be changes in curriculum. Certain programs may be de-emphasized or even eliminated in order to focus on majors and programs that help students get jobs after they graduate. This also may mean that faculty hiring and evaluation criteria could change, and certainly institutions, if this plan is followed, would need to increase the resources they use to encourage student persistence and raise graduation rates. Next slide, please. So what's going to happen? Well, it's pretty clear that there will be some new accrediting organizations, and they probably will have agendas that differ from those of the traditional organizations that have accredited our colleges and universities for decades. Some of these traditional accrediting organizations may in fact be derecognized, which means that an institution will have to find a different accrediting association to work with rather than the one that it was accustomed to working with for a long time. This may also lead to loss of participation by certain colleges in the federal student aid program if they cannot or will not adapt to the requirements of the new accrediting associations, which would be devastating for that college and university to lose all access to federal student aid. And lastly, colleges will need to monitor the status of the accreditors that they have worked with for decades to make sure that they're still in good company on the list that the Secretary of Education releases. And they will need to be flexible in identifying and complying with these new standards. I will say that in conclusion that this is all complicated and difficult to interpret right now. Kim and I have developed a client alert that's on the bond website that gives more information than we were able to do in the short time of this webinar. And we will continue to be looking at this, monitoring what's going on with colleges and universities around the country, and we'll do the best we can to help colleges and universities get through this situation, because it is a complete sea change for higher education. Gabe?
Thank you very much, Barbara and Kim. And as you noted, when there are issues that are of this significance, potential sea change, we certainly want to keep this audience apprised. So Barbara and Kim, please come back on if there are more refined understandings of all this over time. But really, thank you for taking the time to bring the audience up to speed. We encourage all of you to head onto our website and to find the fuller information in the information memo if you are looking to dive more deeply. If Kathy, you'd please go to the next slide as we wrap things up. Let me make sure that all of you are aware of our employment law conferences, which we host annually in the spring. And here we are in the spring. They are taking place basically in every major geography in New York State. I'll personally be involved in both New York City's and Westchester's, and there are many colleagues whom you will likely know from the webinar who will also be taking part in hosting these and otherwise presenting across the state. We really look forward to having you there. The feedback that we get each year is that these are worthwhile to attendees. So please reach out to me or to anyone else if you have questions, and of course to the link via the URL at the bottom of the slide if you're ready to register. So with that, let me take us to our close. The contact information for our presenters today is here. I will be back with you in 2 weeks' time as we cross over into May. You'll first be with Carrie on the 6th, and I will see you on the 13th. In the meanwhile, wishing all of you a terrific end to April, and thank you so much for your consistency in being part of this program. We can't do it without all of you, and we thank you for your loyalty.